Good morning, everybody. Thank you all for joining us. We are going to wait just a couple seconds until everybody makes it in from the waiting room. And we can go ahead and jump into the session today. I am going to start, as I usually do, with some Zoom housekeeping tips. Starting with a request that you keep yourself muted while we're talking, unless you want to unmute yourself to ask a question. Your Zoom toolbar might actually be flashing right now. That's where you find your mute and unmute button, as well as your start and stop video button. So if you need privacy for any reason today, you're working away in the background, having a bad hair day, as I often say, you're welcome to keep your video off, but you are also welcome to have it on if you'd like us to be able to see you. Again, that's where the mute button is, so please do stay muted unless you want to unmute yourself to ask a question. I did just put a message into the chat, which is why your icon, if it's flashing, might be flashing. And in the message, I share with you that the chat is the best place to ask questions while we're talking today. So we are a little light on prepared questions, and we are likely to have time to get to questions in the chat if you guys have any to share with us today. But if for some reason we don't get to your question today, or if you think of something else that you'd like us to cover for next week or a future session, email your questions to info@condolaw.net by 4 p.m. on Monday afternoon so that we can include it in that week's Q&A session. I also wanted to briefly just let everybody know that we didn't forget to upload the video for last week's Q&A. Somehow, in Zoom's technology wisdom, the recording didn't actually record anywhere. We can't find it either in our account or on the computer for the person who was recording. So you all, anybody who was here got the pop-up saying this session is being recorded, and we tried, but it just didn't take for some reason, because technology is our friend often, but every once in a while not. So please don't email Chelsea asking her why we haven't uploaded the video yet. We tried, it's just not there. But we do record these sessions, and the message I put into the chat also includes a link to our YouTube channel, which is where we upload all of the videos. And the YouTube channel is also a great resource that you can search. So when you go to YouTube, if you go to our channel, not in the general YouTube search bar, but in the channel specific search bar, you can put in search terms to look at videos where we've covered certain topics in the past, which can be a nice tool, unless you're asking for a topic that's super common and that might be included in almost every description. Like, don't do a search for condo, because that's going to be in every one. But you could do a search, for example, for audits, and that can be a useful tool for you there. So I'm going to keep moving and remind everybody, as we do every week, that we are here to cover general information only. We are not here to give legal advice. So number one, if somebody sends you one of our videos or tries to tell you, well, you have to do this thing or you can't do that thing because of something that, you know, Valerie or Katie or Ken or whoever said in a Q&A video, you can ignore that, because this is not legal advice. Every association is different. Every governing statute is different. Every set of governing documents is different. And every set of specific circumstances is different. And nobody can give you legal advice without knowing all of those specifics, in addition to having an attorney-client relationship with your association. So again, general information, not legal advice. And so please proceed accordingly, or govern yourselves accordingly, as some people say. Same thing for the chat. It's for questions and clarification only. So number one, please no arguing in the chat. You guys are all incredibly well behaved. I almost feel like we don't need to say that anymore. And also, nothing in the chat is legal advice, so please keep that in mind as well. The update on the WUCIOA for All bill. It has been, of course, approved, as we shared before, by both houses. It's with the governor right now. I just checked last night. It hasn't been signed yet as of that check, but it is highly likely that the governor is going to sign it. There's no indication otherwise. And that means the statute will take effect January 1st of 2028. So there's a lot of lead time here. And we want to remind folks of a few different things. Number one, you don't have to amend your documents, even if they're completely inconsistent with what WUCIOA for All eventually is going to provide for all communities. If there's a conflict between the statute and your governing documents, the statute will just trump your governing documents. And so even though that might be confusing, and we do think that it's a reason for communities to sort of plan and budget over time to eventually, you know, bring your documents in compliance, You're not going to, I don't know, cease to exist as an association or somehow be in violation of the law if you don't amend your documents before that effective date of January 1st, 2028. So keep that in mind. The other thing that I want to remind everybody is that at least for those clients that have been working with our firm on governing documents, you can adopt WUCIOA before the bill goes into effect if you want to. And all of the restatements, both of the declaration and bylaws that we've done since at least 2019 are already consistent with the upcoming statute and the changes that are going to take effect in 2028. So if you are already working on a restatement process, you're already looking at amending your governing documents, you can choose to either adopt WUCIOA as a statute, lock, stock, and barrel, or you can simply adopt documents that are consistent with it without adopting the whole statute. And then you won't, I mean, there will be hardly a blip when the law goes into effect because your documents will already be consistent with it. So Katie, I think you look like you have something to add, so jump in.
I do, and I know that we don't normally do questions while we're doing our opening remarks, but there is a relevant question about the status of WUCIOA that I thought would just be a quick answer, which is basically it hasn't been signed by the governor yet. Is this delay unusual? And the answer is no, because he has, I think, what, 20 days to sign it?
He has a period of time to sign the bills, and by the end of that time, if he hasn't signed it, all of the bills that were passed by the legislature will automatically go into effect or become the law as of their effective date. And so the only way that WUCIOA for all would not take effect is if the governor vetoed it, and there has been absolutely no indication that that's going to happen. So no, it's not unusual at all. If he doesn't sign it, it will automatically become the law anyways, and we expect that he will sign it. Thanks, Katie. All right, I'm going to keep moving here. We did tell you guys a couple of times over the last couple of weeks, and we probably will stop announcing this every week, but just as a brief reminder, an update to the Corporate Transparency Act, that a federal district court judge in Alabama has held that the Corporate Transparency Act is unconstitutional. And that case is likely going to be appealed to the 11th Circuit and probably even eventually to the United States Supreme Court. And so this does create a little bit more uncertainty and may support a wait and see approach when it comes to associations trying to decide when and whether to comply with the requirements of the act. It's possible that the case will be stayed. The outcome of the case essentially will be stayed pending the appeal. And so we don't really know exactly how that's all going to play out. We will keep you informed as we learn of any developments with that case or any other cases that affect the effective date of the CTA, which I think is next January 1. And there are also other efforts happening right now to either delay the effective date of the CTA and or create a carve-out exception for community associations. So, you know, as always, consult with your association attorney as you decide how to handle the Corporate Transparency Act and when and how to comply with the reporting requirements. But we will keep you posted as to any updates of this nature once we learn of them. And then our last announcement that we've been making for a little while now is that WSCAI's Annual Conference is coming up. It is the weekend of April 19th at the Sheraton Grand, Seattle. I just put a link and some information into the chat. We're going to be there. We hope to see many of you guys there. It's a great opportunity to see people face to face and in person, and to do a lot of learning. So it's a combination of two different conferences that WSCAI used to hold annually, one of which is Managers Only Day and one of which is Law Day. So there is a legal panel. There are lots of different legal educational seminars that will be happening there. We'll have a booth. So even if you don't, aren't excited so much about the educational stuff, which you should be, you can come visit us at the booth. And also the LAC, the Legislative Action Committee, is hosting a dinner and a fundraiser there. And we would love, love, love to sell that dinner out. I think there's something like maybe 30 tickets left. So you don't have to attend the conference in order to attend the LAC dinner. So if you're not sure about committing to a 2.5-day conference, but you're interested in supporting the work that the Legislative Action Committee does, feel free to send me an email and I'll connect you with Kyle or Beth at WSCAI so you can buy tickets to that dinner. And I think at this point, we're going to just jump into the questions without any further ado. So you want to take it away, Katie?
Sure. So first question for today is, with loss of use, we have an elevator that will be down for about a month during modernization. Some owners want the board to pay for their hotel stay during the month. Is this an association responsibility? So our gut reaction is no, but as always, check your declaration and your governing documents. Nearly all declarations specify that associations are not liable for an owner's loss of use due to repairs. That goes for if the loss of use is to their unit or an elevator. So we couldn't tell from the question kind of what it was referring to. So the association is also not responsible for relocation costs, as I just mentioned, during either modernization or damage repair or repairs when there is a damage event. Usually individual owners have insurance coverage for these types of things, so they should talk to their own insurance providers. And it also is probably worth looking at your local codes to see if there is a requirement that you might have to cover these costs. We couldn't find any for Seattle, but we think that at least Issaquah has a code that requires apartment owners and condominium associations to provide alternative housing or alternate means of access to the unit for disabled residents when an elevator is out of service. So if you have a specific question about what you have to pay for and you need help seeing if your jurisdiction has a code, it might be worth Google or contacting your association attorney. Valerie, do you have anything to add?
Well, I keep meaning to buy a coffee mug that says, do not confuse your Google search with my law degree. So I'm going to recommend that instead of just Googling your local code, that you actually just pay your attorney for half an hour of time to get their advice on what local code might apply to your particular situation. And in part, it's not just because this is something that your association attorney should know that might not be as straightforward as a Google search. It's also because when you get advice from your legal counsel, there is some shifting of risk that happens there. And also the association board is fulfilling at least a part of its duty of care to investigate what is a reasonable thing to do in a certain situation when it asks its legal expert for advice on what to do in a situation.
Yes, I'm not disagreeing with anything you said. I had another thought that came up with, there is a difference, because what I just mentioned was if an owner is disabled, there is a difference between a request for an accommodation and modification versus someone who is just displaced, who is an able-bodied person with like using the elevator and whatnot. So that is, I guess, another reason to contact your attorney, is to be able to navigate this difference and if those differences in facts may exist.
That's a great point, Katie. All right, we're going to move on to the next question. Our very small condo HOA, 8 units, is self-managed. There are 4 board members. The board picks and chooses which parts of the CC&Rs they want to enforce. They frequently just make stuff up. They aren't even aware of the RCWs governing condominium associations. And one of the board members doesn't live here and yet seems to be the one that's running the show. What are my options? I was on the board for 20 years and I finally decided that I'd had enough. So again, broken record here, but I'm going to start by saying we cannot tell you what your options are. This is not advice for you. We're going to comment generally about this situation in a way that we hope is broadly helpful to different people that might be experiencing one facet of this or something similar, but we can't give you legal advice. And so if you want somebody to tell you what your specific options are, then you need to go hire an attorney and pay them to give you that advice. So I'm going to start by saying this. Just as board members are elected by the community, the ownership as a whole, they can generally only be removed by the ownership as a whole. So if part of the desire here is to remove somebody from the board, you have to call a special meeting of the community for the specific purpose of voting someone off the board. And at that meeting, you have to allow the board member that is being subject to removal an opportunity to address the ownership before the vote takes place. And I think it's worth noting that removing a board member entirely is actually difficult, and most efforts to do so fail. So you would want to try to ensure pretty broad support for removal before going through the time and expense of calling a special meeting for that purpose. And I also want to clarify that the privilege of calling the meeting belongs to the board, but most documents and the statutes, if the documents are silent, do have a process by which, if you get the support of a certain percentage of the ownership, then you submit a request to the board to call a special meeting for whatever the purpose is that's identified in that request from the owners. So there's a process that you have to follow in order to do this, and you want to make sure you follow that. Unit owners that are not on the board don't have the right to just randomly call a meeting of the association for any purpose. So I just wanted to make sure that, just like we tell associations that a process matters, it also matters when you're an owner trying to act on your own behalf. If a board member is truly checked out, if that's part of the problem, like they don't attend meetings or they're just kind of passive and they just let one board member do what they want all the time, you can ask them to resign. And if they do, then the remaining board members can appoint a replacement board member to serve out the rest of that person's term until you have, your next election. The board as a whole can also vote on its own to strip an officer of their officer position. So if your, vice president is the one that's checked out or that is doing a bad job, the board as a whole can say, okay, we're stripping you of your vice president title and officership, but the board on its own can't remove that board member entirely from the board. Again, that requires a vote of the ownership. It's also worth noting that owners can sue the association to enforce the declaration. So if you don't like how your board is enforcing the declaration, and you can decide if that is if you dislike it intensely enough to pay an attorney and file a lawsuit against the association to enforce the declaration, or against a neighbor, for example, if it's a particular owner that's violating the declaration that you don't like. Not that you don't like the owner, but you don't like the action or the lack of enforcement, right? Don't file lawsuits just because you don't like people. So individual owners do have the power to enforce the declaration by filing a lawsuit to do so. Also, people can run for the board, or if things get bad enough, you can choose to sell your unit and leave the community so that you don't have to deal with it anymore. And, I'll offer some comments that are probably uniquely helpful to a small association, which this appears to be. I mean, 8 units, you're never getting away from those people. There's no insulation, right? Like, you live with those people, you share, you're in the same building, you share a parking lot. Like, those are your neighbors, your very, 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 very close neighbors, for better or for worse, until you no longer live within the community. And I think community living, even in a larger community, you have to acknowledge some of the challenges that go along with living in multifamily housing. But some of those challenges are intensified when it's such a small community. And so all of these options that we were talking about, one of the things that we think is really unique about our practice area, and one of the things we try to always keep in mind when we're advising our association clients on how to handle disputes with owners or compliance issues, is, once that dispute is over, you still got to deal with that person because they're still a member of your community. And the same is true when you as an individual owner are trying to figure out what to do about deficiencies that you perceive to be happening at the board level, because you might be right and you might even win, but then you still have to live in that community with those folks. And so sometimes it is a reasonable option to say, I'm done. I served on the board for 20 years. These people are just acting like it's the wild, wild west, and I don't have the time or the energy for this. So bye, Felicia. Like, I'm going to sell my unit and I'm out of here. So, we always hesitate to put that in our list of options when a question like this comes up, because it does seem, number one, extreme, and also a little flippant. Like, well, if you don't like it, just sell your unit. Understand that we understand that is not a decision any owner would make lightly, but I think we would be remiss if we didn't include it in the list of options when we're talking about this topic. The other suggestion, one other thing that you can do is, and a community can amend their bylaws to remove board members who don't actively participate and govern the community. So we often will draft bylaws to include a section that automatically removes board members who miss 3 consecutive meetings in a row. So that is something, of course, that would require the buy-in of your board, because you as an owner don't have the authority to amend documents without the buy-in of the board. And depending on your documents, your bylaws could be amended by a board vote only, or might require a vote of the ownership to amend. Both are possible, just depending on what your documents say. But it is one option that your community could consider. Katie, did you have anything you wanted to add to that one?
Yeah, the only thing I'd add is that, and it may not, I don't know the dynamics of this board in this community, but sometimes when new board members are elected, they may not know what they don't know. And there are a lot of rules and regulations and duties and RCWs and your declaration that board members have to follow. And it may be that they just need to be educated. So someone, and again, this may not apply to the person who asked the question, but it may apply to other people, where sometimes just educating board members, if someone else has all this knowledge, can change things.
Yeah, and not just you educating them directly, but things like telling them about this Q&A, telling them about WSCAI, giving them a copy of the WSCAI journal if you happen to have one, or of our handbook that we've published in the past. There are tons of resources out there that can be handed to board members. And also, we realize that you can lead a horse to water, but you cannot make it drink. So you have to, at a certain point, if this is you in the situation of like, I'm trying, it's like talking to a brick wall, at a certain point, you just have to let it go and realize this is your reality and decide what you have to do about it so that you don't, live in constant frustration, basically. You have to accept what you cannot change, right? What's that serenity thing? Every time I say the word serenity, I think of Serenity Now from Seinfeld. Anyways, I'm dating myself. Sometimes you just have to realize you have done what you can. And if the board is not willing to educate itself and make itself better, then either you volunteer to get back on the board, you resign yourself to living with the reality of your community as it currently exists, or, you decide to sell because it's not, it's untenable for you. So I don't want to spend too much more time on that, but I'm ready to move on to the next question unless Katie, you had anything else to add? No? Okay. It is my understanding that RCW 6490-480 requires utilities to be billed based upon usage, i.e. via submeter, if the declaration stipulates that utilities are not common expenses. If utility submeters are broken or corrupted, would there be a reasonable allowance for the association to bill utilities based on the percentage of ownership until the submeters are repaired? Once the submeters are repaired, would the association have an obligation to retroactively reconcile past bills that were not billed using submeter data? So I want to start by saying this answer and this question, this topic really is only relevant right now to WUCIOA communities, because this is from WUCIOA RCW 6490-480, which is not one of the sections of WUCIOA that is applicable to other communities. And I also want to say that we can't answer this question for any specific community without reviewing the governing documents, because what the statute actually says, starting at subsection 4, is the declaration may provide that any of the following expenses of the association must be assessed against the units on some basis other than common expense liability. If and to the extent the declaration so provides, the association must assess the costs of one or more specified utilities in proportion to respective usage or upon the same basis as such utility charges are made by the utility provider. So that's a mouthful, but in other words, this says that if the declaration provides for it, you can assess utilities based upon usage. But if the declaration is silent, utilities are treated as a common expense. They're included in the budget, and therefore they're paid for based upon the percentage allocation, the common expense liability for each unit, right? So it depends on what your governing documents say. It depends on what your declaration says. If your declaration requires that utilities be assessed based upon usage and your submeters break, then you are left with the question of what is reasonable, because the board needs to act reasonably. And, there's no case out there that's specifically on point to this question in our jurisdiction, but we think that we think a big part of our job actually is doing our best to make an educated guess on what a court might find to be reasonable in a certain situation, right? And if your submeters actually break and you are being proactive about getting them repaired, and there is a period of time during which you don't have any submetering data, as long as you are being proactive, you're taking reasonable steps to get the submeters repaired, and in the meantime, you're assessing those costs in proportion to treating them as a common expense, right? Like, just put it the most simple way that I can. I think it's highly likely that a judge would find that to be reasonable. I think that another alternative would be that during that time frame during which your submeters are broken, you choose not to assess utility costs to your owners. The reality is the outcome of that's exactly the same thing as treating as a common expense, right? Because the money's got to come from somewhere. So if you're just reallocating it from a different part of your budget, the owners are paying for it one way or the other anyways. I don't know how you would reconcile the bills after the fact. If you have, let's say there's a 90-day gap during which you have no submetering data, and then you get the submeters fixed. Part of the question was, do we have an obligation to retroactively reconcile past bills that weren't billed using the submeter data? I don't know how you would do that without submetering data. So I don't know that that is necessary. I also think it's probably impractical and maybe not even possible, depending on the circumstances. So I think that the sort of takeaways, the TLDR of this answer is your mileage may vary based on what your governing documents say. Your actions as a board have to be reasonable under the circumstances. And if you have a specific question about how your community should handle this, then you should consult with your association attorney. Katie, did you have anything you wanted to add to that?
And also check if you have submetering, check and make sure that they're working, maybe on like an annual basis. And that may help kind of avoid some issues if like you go for like a 3-year period or something and aren't getting them fixed. So that might save a little heartache. Other than that, I will move on to the next question, which is, can you please explain what a leasehold estate affecting the common interest community in the context of the following statute is? So RCW 6490 640 1P is what the person is talking about. And it says a statement, this is talking about resale certificates and what you have to provide, which is a statement of the remaining term of any leasehold estate affecting the common interest community and the provisions governing any extension or renewal of the leasehold estate. So in the context of this statute, and pretty much the question is, what is a leasehold estate? And it is a property rental or lease with a very, very long term, like 99 years. So we have several clients who have a variation of these leasehold estates. One of them is a 99-year lease for the condominium to be on Native American land. They rent the land that the condominium sits on. And another one is a condo built on a golf course that, again, is a 99-year lease. We also know of a downtown condo that has a 99-year lease for the parking garage for all the spaces that are assigned parking. So when that 99-year lease is up, those parking spaces may go away. We don't know. It's not our client. But so that's what it is. It basically is, in your resale certificate, you have to say if there is this type of rental or lease that the common interest community is subject to, so that the owners know if that may be expiring. Valerie, anything to add on that?
Yeah, 2 things. One is they're almost always renewed. So the lease is typically for that 99-year term. And a lot of people are like, why would you ever build a condo on property that you don't own if it's just going to go back to the property owner after 99 years? As a practical matter, they're almost always renewed for successive 99-year terms.
Right.
So that's just something to be aware of. The other thing that I'll say is, if you have no idea what a leasehold estate is, you probably don't have one. Because you would know if, I mean, unless, you know, I don't know, unless it was a really old association that had lost records or something like that. It's highly unlikely that you are dealing with a community that has a leasehold estate if you don't even know what that is. So I hope that doesn't sound like dismissive or flippant. I don't mean it in that way, but it's not the kind of thing that like is super common and that you could just accidentally overlook for the most part.
The only other thing I'd add, because I feel like I just want to say why 99 years, is because you can't have something that is forever. There's called something that's the rule against
Rule
perpetuities.
against perpetuities. Oh my gosh.
And that's what this is. So it basically,
flashbacks.
it has to be for like the lifetime of someone, which we think is 99 years. And so that's why they automatically renew, is because you can't do it forever. It's just like a little fun fact for the day. All right, I will go on to the next one, which is, we actually received 3 separate questions about this topic. We combined it into one. So if your specific question isn't read, hopefully this topic covers what your question was anyway, which is there a new law, Seattle Fire Code, prohibiting gas grills on balconies, as well as previously banned fire grills? What is the new law? When does it go into effect? Someone says it might go into effect March 15th, that restricts the use of barbecue grills, other open burning devices on balconies within 10 feet of combustible construction in apartments, condos, other multi-resident buildings. And what's the actual code, and is there a notice requirement? So all that boils down to is, yes, recently it has not come to light, but we have learned that at least Seattle and potentially all of Washington state has adopted the 2021 version of the fire code starting March 15th. Now in Seattle, that becomes enforcement starts July 1st. So there is time to get up to the restrictions that I'm about to talk about. In case you want to do your own digging, the section that we're talking about right now of the 2021 Fire Code is 308.1.4, which says that multifamily properties, including condominiums and apartments, cannot use charcoal burners and other open flame cooking devices on combustible balconies or within 10 feet of combustible construction. So this means that to operate an open flame cooking device on a balcony, you have to either be 10 feet away from anything that's combustible, or you have to have an automatic sprinkler system that protects the space where the open flame device is used. If your balcony is not combustible, meaning it's made of concrete and rebar, then you're fine, unless there is another combustible thing around you. And we don't know the construction of every building, so we can't answer that. This does not apply to 1 and 2 family dwellings, even if they're a condo. There is also an exception for LP gas cooking devices that have an LP gas container with a water capacity not greater than 2.5 pounds. So if you know what that means, then that's great. I think it has to do with propane, but I don't know what that means. If you have a question about that, contact, honestly, probably your fire department. They can help answer that better. And honestly, if you have a question about if your construction's good enough, if any of this applies to you, you can ask your fire department to come out and do a check and let you know if you're in compliance of any of these things. They're the ones who are going to be able to best assist you with this. It is worth noting that electric barbecues are not subject to this because they're not an open flame. So again, it's only charcoal burning and open flame. That being said, don't change your rules based on what you just heard without talking to your attorney. This is not legal advice to you. That was an overview of the new code that we are still continuing to look into. There may be other updates as it applies to the whole state if you're not in Seattle. And it also may not cover other requirements you have, like insurance, that may place additional restrictions that are independent of this new code and may prohibit grills for different reasons. So if you're looking to change your rules about this, contact your association attorney because they can provide more clear guidance. Valerie, do you want to add anything?
I do not. You covered it all. I'm going to jump to our next question, which we pretty much already covered, but the question is, what is the status of WUCIOA for all now that the legislative session has ended? As I mentioned very beginning of the Q&A today, it's Senate Bill 5796 is the WUCIOA for all bill. It has passed. It is currently awaiting the governor's signature, and it will take effect on January 1st of 2028. I want to remind everybody what we said earlier, which is you don't have to amend your governing documents. If there are any conflicts between your documents and the statute will simply trump them. If you want to start working now to bring your documents into compliance with the statute, you can totally do that. Contact your association attorney to figure out how best to approach any rewrite that you might be looking at. The other thing that's probably worth mentioning is that there are still some provisions of the new statute that our Legislative Action Committee plans to continue working with the legislature on over the next couple of sessions between now and when the bill takes effect. So the bill may change, or the statute may change between now and when it actually takes effect on January 1st of 2028. So we will obviously continue to keep you all informed of those changes as they happen. But as far as this legislative session is concerned, that's the update. And I'm going to pass it back to Katie.
All right. So this next question is about a provision that is currently applicable only to UCIOA communities. Now, as Valerie just said, 4 years down the road, that'll change things unless you adopt UCIOA now. But I just want everyone to keep that in mind as we talk about it. I'm confused about something in RCW 6490-480. It looks like an association can assess owners for the full expense caused by willful misconduct or gross negligence, but can only assess whatever part of the expense is not covered by insurance when the expense is caused by negligence. Is the amount that the association gets reimbursed by insurance considered an expense in subsection 6? Why is there a difference? What do you recommend? So I'm going to put the actual text of the language in the chat.
I got it.
Okay,
I got
cool.
it.
Just so everyone can see what we're talking about instead of reading it. A big overview under subsection 6, the association can assess the entire amount to the owner if the damage is caused by willful misconduct or gross negligence, whether or not there are insurance proceeds. But we don't think you can double dip and get the money from both the insurance and from the owner. What we think the goal of this was to help the association not file a claim under their own policy and allow recovery from an owner when there's willful misconduct or gross negligence. And it's also important that if both of what I'm going to talk about subsection 7 in a second, but this subsection 6 is permissive. So you may assess the expense. You don't have to, but if you want to, you have to give notice and an opportunity to be heard before you make that assessment. This is different than subsection 7, which does also require notice and opportunity to be heard, and is also permissive. So that part's not different. But this subsection 7 talks about regular negligence, and the association can assess the negligent owner after notice and opportunity to be heard, the amount not covered by insurance, only if the declaration says that you can shift the cost. So if your declaration is silent in your UCIOA community and you can't shift the cost caused by regular negligence, but you could assess the cost for damage caused by willful misconduct or gross negligence. So, and this is all like, this is a pretty confusing one. It's a lot to go through, but basically, if the declaration is silent, and I know I'm repeating myself, but I have a point, I swear. If the declaration is silent, you don't have to assess for negligence or you can't assess for negligence. If it's not silent, you can assess for damage caused by willful misconduct or gross negligence, but you don't have to do it for either. The difference between gross negligence and regular negligence is very difficult to decipher. And part of that is because there's no real definition for gross negligence. Part of the definition is it's just really bad negligence. And so what does that mean? It is open to interpretation. So that's kind of the overview of what we're working with. The question did ask what if an expense, insurance proceeds are an expense under subsection 6. And an expense is anything the association has to spend to repair the money. The money that the association receives from the insurance to repair the damage is usually called proceeds. And those proceeds will equal the amount the association has to spend to repair the damage less the deductible. So basically that's roundabout saying, no, insurance proceeds are not expenses, but sometimes they are roughly the same amount. Valerie, do you have anything to add to this one?
Yes. So I think the first thing that I would say is, as a practical matter, if you're dealing with a situation where you think there might be negligence and you're not sure which kind there is, or anytime you're thinking about assessing repair costs to a unit owner, you should consult with your association attorney, because as Katie's answer demonstrates, this is not a simple, straightforward sort of like if A, then B kind of calculus here, right? And it's also worth noting that there are multiple declaration sections that you would have to look at in order to determine if and when the association has the authority to assess a particular cost to a unit owner. And as we beat the drum of procedure, I will remind you that process matters. So even if you have the authority to charge somebody for something, if you do it wrong, that charge can be challenged. So if, for example, the scenario requires notice and an opportunity to be heard, which under this particular statute, it always does, regardless of what kind of negligence we're talking about, you want to make sure that you've actually given someone notice and an opportunity to be heard before you assess that charge to them. And part of why I focus in particular with things like this on the procedure is that we often have accounts that are referred to us for collection with a $10,000 or $15,000 charge that's equal to the amount of the association's deductible because of some situation where the association wanted to be able to charge the owner for the uninsured cost of the damage repairs, only for us to tell them either A, they didn't have the authority to assess that charge, period, under their documents, or B, yeah, you probably had the authority to do it, but you did it wrong, and therefore the charge is not enforceable. And in particular, sometimes these come to us, 6 months, a year, 2 years, 3 years after the damage event. And the longer it is between when the thing happened and when you want us to try to collect the charge, the harder it is to sort of fix minor mistakes in procedure. So consult with your association attorney, not just about whether you have the authority to assess the charge, but about what steps you have to take to do it properly. Part of the question also asked about why the statute was written this way. And, it's we can't really guess, right? But what my reading of the statute suggests, to me anyways, that the legislature believes that there is a difference between ordinary negligence and gross negligence or willful misconduct, and that an association should be able to sort of financially penalize somebody for one, but the penalty should be limited for the other. That's just how I read the statute. I wasn't part of, the negotiations that happened before the statute was adopted by the legislature. It's also worth noting that this statute is based on a model that was established at the national level. And so I'm not sure whether this particular language came straight out of the model or whether that's Washington specific language. I do think the thing I would emphasize the most, other than process and authority, is the thing that Katie said about how difficult it is to determine where the line is between ordinary negligence and gross negligence or willful misconduct. And so again, this is another scenario where I think consult with your association attorney, have them draft you a memo talking about the authority to or to not do a certain thing. And that allows you not only to handle the situation correctly, but also to shift the risk of the decision that the board makes when it relies upon the advice of its attorney in that scenario. So did you have anything else you wanted to add, Katie? All right, we're going to move on to the next question. What is the protocol when an association gets a loan for a repair to common property and the owners are repaying in payments? How can this be attached to the property in the case of a sale or non-payment? So typically, when an association takes out a loan, the collateral that the bank relies upon as sort of, to guarantee the loan is the association's ability to assign its right to collect the special assessment to the bank. And that's the collateral that the bank relies on to make the loan to the association. And because of that, when there's an HOA loan involved, the special assessment is always adopted in a lump sum, meaning it's, $40,000 per unit or whatever, and it's due now. But then there's some provision made for owners who can't pay it up front. They're allowed to participate in the loan and they can make payments over time. There's, usually an interest rate and an amortization schedule that's dictated by the terms of the loan with the bank. In that scenario, if the owner is making the required payments and they're not delinquent, there's typically not a lien that would be recorded, right? Because if they're not delinquent, what's the basis for the lien? And in particular, when it comes to condo associations, which number one, have a statutory lien, but number two, also have a resale certificate requirement, the risk of not having a lien is really low, because whenever that person lists their property to sell it, the title company is going to contact the association, or perhaps the buyer is going to contact the seller, ask for a resale certificate, etc. And the resale certificate should disclose the existence of the special assessment, the balance that's due on the special assessment, any other balances that are due at the time the property is sold. HOAs, pre-WUCIOA HOAs, do not have a resale certificate requirement, and they also do not have a statutory lien. Some of them have what's called an automatic lien that's written into their CC&Rs, but that's about as good as the paper that it's printed on if it's not recorded in the public records and somebody goes and sells that property and the title company doesn't contact the HOA for a payoff, right? So one thing that an association could do if you are an HOA without a resale certificate requirement is you could negotiate with your owners or sort of build into the payment plan option the reality that the association will record a lien for any unit owner that is participating in the loan and making payments over time to mitigate against the risk that the property could be sold without a payoff to the association because of the lack of a resale certificate requirement. If an owner falls behind on the special assessment payments, you have all the same options you would have normally for collecting unpaid assessments. So I don't think that's really the scenario that we're talking about with this question, right? It does depend on any terms that you might have included in the adoption of the special assessment. So some communities, when they adopt a special assessment like this, will have special provisions for either different interest rates or additional late fees or, acceleration of the balance on the special assessment if the owners fall behind on the payments. So one thing that I would recommend is that you consult with your association attorney, not just at the collection stage, but at the adoption of the special assessment stage. And I'm thinking in particular of one client that we have that it had to adopt a very large special assessment in order to qualify for an HOA loan for some really significant repairs in their community. And they did the whole special assessment adoption process without consulting with us. And then they had to redo the whole thing because when it came to us for the loan opinion letter, there were some deficiencies in the process. And if they had just checked with us first, they would have avoided the expense and the headache of having to redo the process. So I think you should check with your association attorney, both as you're contemplating the special assessment and the loan. And then again, of course, if and when somebody falls behind on their payments. So I think that covers, I'm going to look at the question again. Yeah, no, I think that covers the question. But Katie, if you have anything to add, please jump in.
The only thing, just because I think it's a quick answer and it relates to this instead of us going back for questions at the end, is there was a question in the chat earlier before we even talked about this question, which was, can the board add additional late fee to an unpaid special assessment in place? And my thought is, yes, you can charge late fees if owners don't pay the special assessment just like you can for a regular assessment, right?
Well, yes, except I looked at the wording of the question and they're saying, can they charge additional late fees? And so I guess I don't know what you mean by that. We have some communities where they'll send an account to us and they have been charging 2 late fees without any authority to charge 2 late fees because an owner is behind on their regular account and their special account. And, me with the air quotes, legally, there's no difference between regular assessments and special assessments. If you want to be able to charge a special late fee, a separate or additional late fee because of an owner being delinquent on a special assessment, then you need to either adopt a late fee policy that says that, or in the special assessment ratification process and the documentation that's sent to the owners, you have to specifically tell them that. In order to charge any late fee, the board has to adopt the late fee, and then the board has to publish the late fee to the ownership, which essentially means mail it out. Usually you do that by way of a late fee policy or a collection policy, but you can't, just because your management software, for example, has 2 different accounts for the regular assessment and special assessment doesn't automatically mean you get to charge 2 late fees per month if somebody is delinquent on both.
I think you also brought up a good point of what your special assessment notice needs to include if you're charging an additional late fee. It should include that. If there are any additional management costs, those should probably be disclosed in the special assessment notice. And if there's any interest that will increase, owners need to be told of all of this. Otherwise, it may not be collectible.
Yeah.
Which is the reason you should talk to your association attorney before you do it.
Agreed. And the other thing that we have been telling our clients to do is when you are in a community that has a multi-year special assessment, even if your ratification process was perfect 5 years ago when you started the special assessment, you should include notice of that ongoing special assessment amount in your annual budget disclosures to your owners. Because your ownership is not fixed over time. People buy and sell their property within the community over time. And what you don't want is for a new owner to buy in with an ongoing special assessment that wasn't paid off at the time of sale, right? Sometimes the buyer will agree to assume the special assessment, but you don't want that owner to say, oh, well, you didn't put it in the budget document, so I wasn't aware of this. That's not to say that argument would ultimately be successful, but you eliminate that argument or the possibility of that argument by including the special assessment information in your annual budget ratification documents to the ownership every year until those charges fall off at the end of the special assessment. All right, we're going to move on to the next question. Does the statutory limitation on resale certificate fees apply to a management company preparing the certificate on behalf of an association client? And I want to start by saying that this is a very simplified paraphrase of a question that came to us that was very specific. And you know who you are if you're here, the person that submitted this question. We are not able to answer the question as it was phrased because it was very specific and would absolutely require us to give legal advice. So we tried to just sort of answer the question at the most basic level that we could, that we think will be helpful, hopefully to more than just the person who submitted the very specific question. So the statutes limit how much an association can charge for a resale certificate. And the way the statute's worded actually says that an association can charge a reasonable fee that is not to exceed $275 when preparing a resale certificate. So I think as a starting point, what I will offer is that there could be a scenario in which a court decides $275 is actually too high to be reasonable. If it took a board member half an hour to fill out a PDF form and send governing documents to somebody by email when preparing a resale certificate. I have not seen that happen yet. There isn't a court case that I'm relying on when I say that, but I think I would be remiss if I did not point out that the statutory dollar amount is a maximum and that the fee must be reasonable. The other thing that I want to point out is that the statutory obligation to provide a resale certificate to the buyer is the seller's obligation. So at least in theory, the way the statute contemplates this all happening is that the seller requests a resale certificate from the association. The association provides the resale certificate to the seller, and the seller is then supposed to provide the resale certificate to the buyer. In reality, we know that that's not really always how it happens, but that's how the statute contemplates that it happens. And the statute does not govern how much a management company can charge an association to prepare a resale certificate, right? That is governed by the contract between the association and the management company. But if that sum is more than the statutory maximum, the association, at least under the statute, cannot pass the extra cost on to the owner. So I know that in reality, many management companies charge a variety of fees that are in excess of the statutory maximum. We're aware of fees that include things like document fees and rush fees. We also understand that these are often paid without question. And also that usually it's the buyer's agent maybe that goes on to like HomeWise or whatever and requests the resale certificate, and maybe the seller never even actually sees it, which is different than what the statute contemplates. Courts in other jurisdictions have limited fees like this, and have specifically stated that fees like this cannot be charged by an association. But Washington courts have not yet ruled on whether extra fees outside of the statutory maximum resale certificate fee are enforceable or whether they're reasonable. We're generally cautious in this regard and would tell our clients that the association should only charge the seller the maximum that's allowed by the statute and nothing beyond that. But we're not here to, interfere with the contract between a management company and association either. And we think those are two separate questions. So I think that covers the topic generally as well as I can. Katie, if you have anything to add to it, now would be the time.
I don't. And so I'm just going to jump into our last question. And we're going to go through this one pretty quickly because we are running out of time. But the question is, are owners entitled to see how every other owner votes in an election? And first, this is not legal advice, but we're going to talk about it generally. So if I say the word recommend, I don't mean recommend for you. It's just how we interpret it. We think if an owner requested to review the actual ballots cast, that the association should consider redacting the names of the individual unit owners and their unit numbers so that information is not shared. This is because our interpretation of the new records statutory language, which allows the association to withhold or redact information, includes unit files that don't belong to the requesting owner, meaning the ballot of someone who votes, we think, goes into their unit owner file. And unless that unit owner is requesting to see it, that information can be withheld as provided by the statute. And part of that is because the courts have not talked about it. And so our less risky approach for associations, because a court hasn't decided what is included in a unit owner file, would be to err on the side of non-disclosure, because you can't undisclose something. So if the association says, here is the record of the vote cast, and they redact the unit owner's name and identifying information, it's safer for them to have a court say you should have provided that than for the alternative to be true, which is a court say you shouldn't have provided that, but it's too late. As Valerie said earlier, you can't unring a bell. The same thing goes if you do like a spreadsheet with electronic voting, basically taking out any identifying information for how a specific person voted in a spreadsheet would be the least risky option. And that's pretty much it. I would say our short answer is, as it stands right now, we do not think owners are entitled to see specifically how other owners voted in an election. Valerie, do you have anything to add?
Nope, I think that covers it. I think we have time for one of the questions from the chat, and it is, if there is a conflict of interest by a member of the board in a vote of unanimous consent, can a vote be taken if that member recuses themselves? No, unanimity requires that every board member vote. So if you cannot have a board member vote because they're recusing themselves because they're personally, interested in the outcome of that vote, then that is not a unanimous board decision and requires you to hold a board meeting where you achieve quorum and then just take a non-unanimous vote at the board meeting. In particular, I think the risk of something like this, the risk of calling it unanimous with somebody recusing themselves is higher when the likelihood that the decision is going to be challenged is significant. And also a lot of times when board members are recused from a vote, they're really unhappy about it. They're not always really excited about being, barred from voting on that issue, which might mean that there's a higher risk of challenge by that board member. So I think for all of those reasons, including a plain understanding of the word unanimous, which requires everybody to vote, I would say no. Do you disagree, Katie? Because I would love to hear. No,
I don't think so.
Ken and I argue a lot more than you and I do. All right. Well, we are right at 11 o'clock. So we are done for the day. Thank you all for joining us, and we'll see you back here next week. Bye, everybody.